Vice President.
Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation. Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Daniel Duque, Senator Diaruk Timal, and to Senator Dr. Maria Dillon Remy, all of whom are out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. John Heath. Whereas Senator Diaruk Timal is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Mr. John Heath, to be temporarily a member of the Senate with effect from the 11th of June, 2019, and continuing during the absence from Trinidad and Tobago of the said Senator Diaruk Timal, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 10th day of June, 2019. To Ms. Siobhan Eiffel, whereas Senator Dr. Maria Dillon Remy is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ms. Siobhan Eiffel, to be temporarily a member of the Senate with effect from the 11th of June 2019 and continuing during the absence from Trinidad and Tobago of the said Senator Dr. Maria Dillon Remy, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 10th day of June, 2019. Honorable Senators, Senators are required to take the oath.
I, John Heath, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
I, Shimon Eichel, having been appointed a Member of Parliament, do swear by Almighty God that I will bear truth, faith, and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
Honorable Senators, I am currently awaiting a further instrument, so I'm going to crave your indulgence to return to this item on the order paper once that instrument is received. Honorable Senators, I have received the following correspondence from the Speaker of the House of Representatives. Establishment of a Joint Select Committee. At a sitting held on Friday, June 7, 2019, the House of Representatives agreed to the following resolutions. 1. Resolved that in accordance with Standing Order 68-1, the Private Security Industry Bill 2019 be referred to a Joint Select Committee hereby established, and that this committee be empowered to consider and report on the general merits and principles of the bill and report by September 27, 2019. 2. Resolved that, subject to the concurrence of the Senate on the establishment of the Joint Select Committee on the Private Security Industry Bill 2019, the following 6 members be appointed to serve on the committee: Mr. Fitzgerald Hines, MP; Mr. Stuart Young, MP; Mrs. Glenda Jennings-Smith, MP; Brigadier General Retired Ansel Antoine, MP; Mr. David Lee, MP; and Dr. Rudal Munilal, MP. I respectfully request that the Senate be informed of these decisions at the earliest convenience, please. Respectfully, Bridget Mary Aniset George, Speaker of the House.
Bills brought from the House of Representatives on the supplemental order paper. A bill entitled The Miscellaneous Provisions, Petroleum and Petroleum Production Levy and Subsidy Bill 2019 in the name of the Minister of Finance. A bill entitled The Miscellaneous Provisions, Financial Institutions, Securities and Insurance Bill 2019 in the name of the Attorney General.
Leader of Government Business.
Thank you, Madam President. Madam President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the bill be taken on Wednesday, 12th of June, 2019. That is the Bill Roman 2 the Miscellaneous Provisions, Financial Institutions, Securities and Insurance Bill 2019.
Honourable Senators, the question is that the next stage of the bill, namely the Miscellaneous Provisions, Financial Institutions, Security and Insurance Bill 2019, be taken on Wednesday, June the 12th, 2019. Those in favour say aye. Aye. Those against say no. No. The ayes have it. The next stage of the bill will be taken on Wednesday, June the 12th, 2019.
Petitions, papers.
Mr. Vice President.
Madam President, I have the honor to lay the following papers listed on the supplemental order paper in my name. The report of the Teaching Service Commission for the years 2014 to 2017.
Senator Cummings.
Madam President, I have the honor to lay the following paper as listed on the supplemental order paper in my name. The delegation report on the 47th meeting of the Board of Directors of ParlAmericas and the 4th gathering of the ParlAmericas Open Parliament Network, Quito, Ecuador, from 12th March to 14th March 2019.
Reports from committees.
Senator De Freitas.
Thank you, Madam President. Madam President, I have the honor to present the following report as listed on the order paper in my name. The 12th report of the Joint Select Committee on Local Authorities, Service Commissions and Statutory Authorities, including the THA, on an inquiry into occupational safety and health compliance within the public service.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Minister of Health, in light of the outstanding debt of $2.3 million to the St. Augustine Private Hospital for dialysis services, can the Minister advise what will be done to avoid a discontinuation of treatment to dialysis patients?
Minister of Health.
Thank you. Thank you very much, Madam President, and thank you, Senator Mark, for the question. I will not say what will be done. I will say what has been done. When this issue came to my attention Sunday afternoon, I immediately issued instructions that all 37 patients be reassigned to dialysis centers. That was done yesterday, and I must compliment the other dialysis centers whose philosophy is more aligned with the Ministry of Health when it comes to patient care. They gleefully and willingly accepted these 37 patients, both in private dialysis centers and also in the public healthcare system. Madam, so no dialysis will be discontinued. They are already receiving their dialysis. I wish to also state that in September 2018, St. Augustine Private Hospital received checks in the following sums as follows: $243,200, $304,950, $304,000, $274,500, and $290,700. From October 1st to 6th June, which is last week, St. Augustine Private Hospital also received checks in the following sums: $309,700, $312,550, $348,650, and $295,450 up to the 6th of June. The outstanding amounts will be paid at the shortest possible time. Thank you very much, Madam Speaker.
Senator Mark.
Thank you, Madam President. Can the Honourable Minister indicate what is the sum of the total sum outstanding in payments to this particular private institution?
So, Madam Speaker, the sums paid in September 2018 total $1.4 million. The sums paid up to 6 June last week total $1.2 million. The outstanding amount of $2 million will be paid at the shortest possible time. But, Madam Speaker, let me say, Madam President, this government took decisions 2 years ago to beef up and ramp up our delivery within the RHS system, and we have done that because the philosophy has to be patient care first. And the Couva Medical Facility, which will be opened from next month for radiological services, I have indicated that facility will have a massive dialysis center so that we will rely less and less on the private sector for the provision of dialysis services. The other 4 RHAs, Southwest, Eastern, North Central, and Northwest, have also ramped up their capabilities. So more and more, we are depending less and less on the private sector for the delivery of dialysis services. But Couva is going to be a flagship facility for the delivery of massive dialysis services. As a matter of fact, I was supposed to be there at 10 o'clock this morning to do just that, but the team is there because I had to come to answer this question. Finding the location, doing the estimates. And that is what this government is doing, to rely less and less on the private sector and have things done in-house rather than outsourced. Thank you very much, Madam President.
Senator Mark.
Madam President, the Minister did indicate that a number of private centers will be taking up the slack in the interim. Can the Minister identify for the Senate the centers or the private centers that will be taking up the slack during this interim period to satisfy those patients who he said would be redeployed accordingly?
Minister.
Madam Speaker, I don't have the exact names, but they range from centers from San Fernando to Central Trinidad to North Trinidad. So they will be sent. As a matter of fact, some patients even were thankful that they will now be placed in dialysis centers closer to their homes, especially those in South, who didn't want to come up to St. Augustine. So there's a silver lining to all of this. But what is more important to note is that of the 1,100 patients on dialysis in Trinidad and Tobago, it cost the state $78 million. $78 million to the private sector to pay for dialysis. And that is why we took a decision 2 years ago to decrease that reliance. And Couva is going to be a flagship when it comes to renal care very soon. Because the state cannot go on paying $78 million to the private sector. And when you have a cash flow problem, the first thing that you want to do is deny service. That is not what this government is about. That action, in my view, was callous and had no regard for patient care. Thank you very much, Madam President. Yeah.
Questions on notice? Questions for oral answer?
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government is pleased to announce that it will be answering questions number 158, 159, 160, 260, and we ask for a deferral of 2 weeks for question number 259, 261, and 273.
Questions numbers 259, 261, and 273 are deferred for 2 weeks. Senator Mark.
Thank you. Question number 158 to the Minister of Works and Transport.
Minister of Works and Minister of Public Utilities.
Madam President, the National Training and Security Company Limited, MTS, has received no reports, and I quote again, no reports that criminal elements have been intimidating female MTS security officers who have been assigned at any school in the Maracas St. Joseph location. MTS is committed to ensuring a safe and secure environment for all its stakeholders, including female security officers, in all the communities which it serves. MTS recognizes the risks that are associated with security arrangements and has protocols in place to allow any officer to get more immediate support in effectively dealing with any security threats which may occur. In this regard, there's close collaboration with the other arms of the protective service. Madam President, for security purposes, the details of these protocols, of course, cannot be divulged.
Is the Minister aware, through you, of recent instances of attacks which occurred in this community directed at female MTS security officers? Is the Minister aware of recent instances?
Senator Mark, that question is just a restatement of the question that the Minister has answered. So can you ask another supplemental?
No, I'll go to the next one.
Okay. Next question, Senator Mark.
Question 159 to the Minister of Community Development, Culture and the Arts.
Minister of Community Development, Culture and the Arts.
Thank you, Madam President. Madam President, steel bands are private organizations which seek sponsorship without the involvement of government. Notwithstanding that, the government has contributed in excess of 80 million in the annual panorama competitions over the last 3.5 years, and the Ministry of Community Development, Culture and the Arts continues to provide assistance to bands for this event. Grant funding is also provided to bands for specific projects.
Senator Mark.
Madam President, given the importance of our national instrument, the steel pan, and the situation that confront many steel bands in Trinidad and Tobago, can the Minister indicate whether any discussions will be taking place between Pan Trinbago and the Ministry with a view to trying to resolve the sponsorship question affecting many steel band organizations?
Minister.
Thank you, Madam President. Madam President, discussions between the Ministry and Pan Trinbago take place on a regular basis, and some of the very important challenges facing the steel band movement are discussed, and certainly the issue of sponsorship and the issue of bands being able to become more self-sufficient has played a foremost role in our discussions and will continue to do so as the time goes by.
Senator Mark.
Madam President, can the Minister indicate, based on those discussions between Pan Trinbago and the Ministry, can the Minister identify any initiatives that would have been agreed upon with a view to addressing this challenge faced by the steel band movement in terms of lack of sponsorship?
Minister.
Madam President, thank you. Madam President, the issue of sponsorship is but one of the issues that face the steel band movement. Other very pressing issues are ensuring that the steel band movement really is robust and that steel bands that perform at Panorama do contribute to their communities outside of the carnival season. And so this issue of sponsorship and self-sustainability, which is the fundamental issue here, is not something that is just tied to sponsorship. And so our discussions with Pan Trinbago are quite more fulsome than that, and they really deal with the essence of the contribution of the steel band industry to the communities. So yes, sponsorship is a part of our discussions, but really the discussion has gone much deeper than that and deals with how steel bands contribute to their community and how they sustain themselves in the light of decreased sponsorship that many of them are facing, and also in light of the fact that we expect the steel bands to contribute not only at carnival time when assistance is provided by the government for them to be a steel band. So the discussions, yes, are continuing with Pan Trinbago and are centered about their sustainability, not simply their sponsorship.
Senator Mark.
Is the Minister, or can the Minister indicate whether she has seen evidence of progress as it relates to their contributions, that is, the steel bands, to their communities, as well as through that process, the development of self-sustainability. Can you share with the Senate whether you are satisfied that positive efforts are being made by the steel band movement to realize those two objectives that you have outlined?
Minister.
Thank you, Madam President. Though I do not see this question falling under this particular, I don't see the supplemental relating that much. However, I will take the opportunity to indicate that the Ministry of Community Development, Culture and the Arts has a flagship program called Music Schools in the Communities, where we partner during the long holiday with steel band and steel bands in different areas. And that aim is to ensure that they register their children, and the children, the young people most certainly, in the community and in the steel bands, learn to read music, and that the steel bands themselves get the parents more involved and look for ways to raise money. And I would indicate to the Senate, this Honorable House, that that has been working wonders in the communities that have been taking part in this program. And we have seen steel bands move from being totally dependent on grant funding to taking upon themselves the responsibility of raising their funds, having different events to do that, and also ensuring that their young members are now becoming literate with music, and so that they are not just playing pan, but they are reading music. And of course, all of the attributes that come with that are accorded unto them. And so yes, progress is being made, and we expect more progress to be made as these discussions bear fruit.
Next question, Senator Mark.
Question number 160 to the Minister of Health.
Minister of Health.
Thank you very much, Madam President. Prior to September 2015, the National Cancer Registry had a time of 7 years of data. This was primarily due to the absence of a registrar to validate the data. Post-September 2015, under this government, the Minister of Health has implemented several initiatives in improving the National Cancer Registry, including 1, the employment of a registrar to access and validate data, started training with international partners, including the International Agency for Research on Cancer, the National Cancer Institute in the United States, and the North American Association of Central Cancer Registries. 3, restarted data collection in Tobago, was not done. 4, validation and confirmation on the data from 2008 to 2014. See how far back we have to go? The key measures required to improve the National Cancer Registry, which is essential to data gathering and policy making, include 1, the upgrade of software equipment. 2, to provide adequate staffing with the required skill set and competencies. 3, formalize the National Cancer Registry as a national entity within the Ministry of Health with the authority to manage and coordinate cancer data for the country. And 4thly, to standardize the data collection and report tools. The above measures should be implemented through the Health Services Support Program. In the first instance, there will be an upgrade of the National Cancer Registry by the end of fiscal 2019, and thereafter, the development of other national health registries, including, and not limited to, diabetes, stroke, and heart disease during the fiscal year 2020. Thank you very much, Madam President.
Madam President, through you, can the Minister indicate whether he's aware of a statement attributed to the chairman of the Cancer Society in a Guardian story dated the 3rd of February of this year, in which, Madam President, it was stated that the National Cancer Registry is defunct. Is the Minister aware of that? And is the Minister aware of this statement?
Madam Speaker, I just said what we are doing, because it was defunct prior to September 2015. Senator Mark is correct. Dr. Lackey said that, because under your tenure, you did absolutely nothing. And I have outlined everything that we are doing. But more importantly, we have started collecting data. For the first time in this country, we had a great Pap smear initiative. 3 installments in North Central RHA. We screened 335 women. We got 9 at stage 1 or precancerous, never before done. The second installation, we screened 500 women. We got 25 precancerous, never before done. Saturday gone, I was there. We screened 800 women. The results will come in soon. We had a prostate screening for 1,000 men, never before attempted in this country. And we got 115 men with elevated PSA levels. That is what this government is doing. Never, ever, ever by any government has an attempt been made to do this type of national screening, because in Trinidad and Tobago, we tend to catch people at stage 2, 3, and 4, where the treatment is not only more expensive, but the outcome for the patient is not as good. But by doing this type of screening, we can catch more men and women at the precancerous stage or stage 1, where the treatment is less of a burden for them and the state, but more importantly, the patient leads a more productive life, and morbidity rates and mortality rates will drop. That is what this government is doing. Thank you again, Madam President.
After 4 years, I'm happy to hear that you are doing these things. But may I ask, through the Honorable President, for the Minister to share with this Senate, what is the level of staffing required to formalize the National Cancer Registry? What is the level of staffing required?
Minister.
So it is more than the zero that was there prior to September 2015. And I said clearly in my answer, the employment of a registrar. The first thing you have to do is to get a registrar to validate data. Without a registrar, no data can be validated or trusted. And I said that clearly in the body of my answer. I also said clearly, restarted data collection. You will need staff for data collection. I said clearly, validation and confirmation of data from 2008 to 2014. That will require staffing. I also said in the body of my answer, provide adequate staffing with the required skill set and competencies. Those will require staffing. I don't have the actual numbers, but they will require staffing. But the most important person is the registrar. And when I say this, let me repeat the first paragraph. Prior to September 2015, the National Cancer Registry had a time lag of 7 years, which was primarily due to the absence of a registrar. No one filled that post. We have filled it. And therefore, everything else will flow from that very important appointment. Again, Madam President, I thank you.
When the post of registrar was filled?
Minister.
The post of registrar was filled under this administration after, I don't have those details here, but it was filled after we came into office. Before September 20, let me repeat, Madam President, prior to September 2015, the National Cancer Registry had a time lag of 7 years for data. This was primarily due to the absence of a registrar. Post-September 2015, under this government, the Minister of Health implemented several initiatives, and the first thing we did after September 15 under this government was the employment of a registrar. I don't have the exact date, but it was done under this administration when this administration assumed the reins of authority in Trinidad and Tobago. Again, thank you very much, Madam President.
Senator Mark.
Madam President, in light of this outgoing administration, may I ask the distinguished Minister of Health whether he can share with the Senate when will the formalization of the National Cancer Registry materialize? When can we expect the formalization of this important institution called the National Cancer Registry to be formalized, Madam President.
Minister.
And I admire Senator Mark's capacity for self-flagellation. Madam Speaker, I said clearly in the last paragraph of my answer, so we could prevent self-flagellation, the above measures should be implemented through the Health Services Support Program. In the first instance, there will be an upgrade of the National Cancer Registry by the end of fiscal 2019, which is just about 3 or 4 months away. I said that clearly. And thereafter, then the development of other national health registries, including diabetes, stroke, and heart disease during fiscal year 2020. It is only this administration has placed these registries as a front burner issue. But Madam Speaker, you cannot separate the registries. Madam President, you cannot separate the registries from the work that my colleague Senator Camille Robinson-Regis is doing with an independent National Institute Statistics of Trinidad and Tobago. Because we have to have robust data collection to drive policy. And part of that recommendation is to have a proper CSO, it will be renamed, I suppose, under a National Institute of Statistics. That is what we are doing. That is what this government is doing. A holistic, whole of government, whole of society approach on the whole issue of data collection, so that the 9 women we caught in precancerous stages, plus the 25, plus the 115 men with elevated PSA levels, will go into that database now. And as I said, the National Cancer Registry before the end of fiscal 2019, and thereafter the other registries before the end of fiscal 2020. Again, Madam President, I want to thank you.
Senator Obika, next question.
Thank you, Madam President. Question number 260 to the Minister of Trade and Industry.
Minister of Trade and Industry.
Thank you, Madam President. The draft National Trade Policy of Trinidad and Tobago 2019 to 2023 has been completed and is before the Cabinet for consideration. And given its importance to the country's trade and industrial environment, appropriate time and care were given to its development. Thank you.
Senator Obika.
Thank you very much, Madam President. Can the Honourable Minister indicate when would the National Trade Policy be expected to be in operation?
Minister.
It should be in operation within the month, within 1 month.
Senator Obika.
Thank you very much, Madam President. Regarding a main outcome of a trade policy is measurement and setting standards for utilization of trade agreements. Can the Minister give an indication as to where is this featured in the trade policy?
No, that question doesn't arise.
Then can the Honourable Minister indicate, based on the trade policy, which markets are going to be focused on for the public's benefit?
That question also does not arise. Any further? No? Let me just go back. Honourable Senators, I would like to revert to item 2 on the order paper, which is the swearing in of a temporary senator. So, Honourable Senators, I am in receipt of the correspondence from Her Excellency the President, Paula May Weeks, ORTT, to Mr. Ndale Young. Whereas Senator Daniel Duque is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate with effect from the 11th of June 2019 and continuing during the absence from Trinidad and Tobago of Senator Daniel Duque. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 11th day of June 2019. Honourable Senators, a senator is required to take the oath.
I, Ndale Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
Lead business.
Thank you very much, Madam President. Madam President, having regard to the correspondence from the Speaker of the House in relation to the establishment of a joint select committee to consider and report by September 27, 2019 on the Private Security Industries Bill 2019, I beg to move that the Senate concur with the House of Representatives in the establishment of the committee, and that the following 6 senators be appointed to serve: Mr. Clarence Rambarat, Mr. Nigel De Freitas, Mr. Foster Cummins, Mr. Saddam Hosein, Mr. Paul Richards, and Dr. Varma Dialsing.
Honourable Senators, the question is that the Senate concur with the House of Representatives in the establishment of a joint select committee to consider and report by September the 27th, 2019 on the Private Security Industry Bill 2019, and that the following 6 senators be appointed to serve: Mr. Clarence Rambarat, Mr. Nigel De Freitas, Mr. Foster Cummings, Mr. Saddam Hosein, Mr. Paul Richards, Dr. Varma Dialsing. Those in favour say aye. Aye. Those against say no. The ayes have it.
Public business, government business, bills, second reading.
Attorney General.
Thank you, Madam President. Again, I thank my learned colleagues for that very warm welcome to this honourable chamber. It's becoming habitual almost. Perhaps I'm so frequent a visitor here that it is lost upon my colleagues. Madam President, I beg to move that an act to amend the Bail Act, Chapter 460, be now read a second time. I'm hearing the good humor coming from my learned colleague, Senator Saddam Hosein, about San Fernando West. And I note that we appear to have a migrant problem in San Fernando. So many people were trucked in for last night's meeting that the traffic flow out of San Fernando to north was so heavy. So, Madam Speaker, perhaps the ministry will look at providing amnesty in San Fernando for imported persons as we register all of the people that come to our shores in San Fernando West. We will simply say, "Wheel and come again, good friends." Madam Speaker, Madam President, it gives me great pleasure to bring a very serious issue to this House. I will confess, Madam Speaker, that this is no easy bill. This bill grips a very central issue of how we as a society intend to manage a phenomenon which I propose to address from a statistical point of view of how crime has gripped our society. There are many moving parts to this equation. Today we're considering an amendment to the Bail Act. I'll go through the history in a short moment. I'll take the Honourable Senate through the underpinnings which birthed the 1994 legislation, the amendments which took us to 2015, those which happened in 2016, 2017, 2018, and then we will come back to this bill. But, Madam President, if I can say squarely to everyone here, there is a constitutional test obviously inside of this legislation. The fact is that we do come with this legislation properly touching and treating with Section 4 and 5 rights in the Constitution, entrenched rights. There is specific mention of the provisions of bail, the right of due process, the concepts in the deeper constitutional arrangements of separation of powers as it relates to the legislature and the judiciary. All of that is properly accepted. The question is, in considering a Section 13 application to pass this law, that is a law in respect of which Section 4 and 5 rights are touched. That is the right to bail, the issue of separation of powers. Section 4 and 5 rights being touched. Are we simply safe with saying it's passed by 3/5 majority? That is, 3/5 of the members present in this House said yes. Is it just a numerical equation of 3/5? Or must we consider the deeper dynamic of what is proportionate in a society such as Trinidad and Tobago that has a regard for democracy such as we have? Now, I'm obliged to be fairly legal today, and I'll try my best as well to be as pointed to the observer who may be listening to these proceedings who are not lawyers. And the reason why I need to be fairly complex on the law is that this law touches and concerns something which we are confident will go to the courts. There will be a test on this law. In any circumstance, one can reasonably expect that. So let's get to the bill before us. The bill before us proposes, in 7 clauses, an amendment to the Bail Act. The Bail Act, which was birthed in 1994, under the hand of then Attorney General Keith Sobian, particularly in the House of Representatives on Monday, August 12, 1994, Attorney General Sobian recognized that the bail laws were in a state of common law, some judicial direction, some degree of statutory guidance, and Attorney General Sobian went through the history of the bail law, starting with the 1983 Law Commission paper, the bail bill in 1985, the drafts in 1986, the 1988 bills published for public comment, the heavy criticism on the 1988 legislation, the fact that those bills were never laid in Parliament, then the Hayatali Commission, then the 1994 bills trying to achieve a regulatory form of balance as the 1994 law was birthed. The 1994 legislation, and I'm going to do this as I centered upon the amendments last night, I'm going to ask my team to circulate a marked up version of the Bail Act 1994 as it is proposed to be amended. On that marked up version, honorable members will see what the law currently stands at. I've used 3 highlighted areas. Those in green will show you the amendments we made in the Family and Children Division Act number 6 of 2016. Those in yellow will deal with the 2017 amendments, which we put into effect as a Senate ourselves, being Act number 11 of 2017. Those in red will be the amendments we made by the Miscellaneous Provisions Supreme Court of Judicature and Children Act number 15 of 2018. And the blue bolded clear text will be what we propose. Now, I'm saying this because if honorable members go on to the laws of Trinidad and Tobago, which are in the course of being revised right now, quite frankly, what you will see there is a mess. Why are the published laws a mess? It's frankly that position because there were so many amendments to the Bail Act in the historical perspective post-1994 that one can easily be confused. So permit me a couple of moments to address these issues. We are today proposing the 16th amendment to the bail laws. We had Act number 19 of 2005, 32 2005, 30 2006. Listen to these now. 10 of 2007, 15 of 2007, 25 of 2007, 3 in that year alone, 17 of 2008, 9 of 2011, 11 of 2011, 12 of 2012, 1 of 2014, 7 of 2015. We as a government dealt with Act number 6 of 2016, number 11 of 2017, number 15 of 2018. So we've had 15 amendments. But in 2016, when we came to the Senate, when we came to the House of Representatives, the UNC specifically denied an extension of the law as it stood in 2016. That 2016 package of bail laws had incorporated all of the amendments, in particular those from 2005 straight up to 2015. And it was in those laws, in that package, in that period of time, that we saw multiple amendments to the Bail Act. Of course, as history will demonstrate, when the UNC is not in power, when they don't comprise the government, they vote against bail legislation. When they are in government, they receive the PNM support, and 3/5 majority laws are birthed. And in particular in 2016, what happened was the law that stood then collapsed entirely, and we went back to the 1994 law, the original 1994 law, as was slightly amended in 2005. What that meant was the laws as they were amended over the period 1994 to 2015 saw a move, no bail absolutely for the first part of the first schedule. In the Bail Act, one will definitely notice that there is no bail provided for Part 1, murder, treason, piracy or hijacking, any offense for which death is the penalty fixed by law. No bail at all. That was saved. That was never challenged. In the period 2005 to 2011, Trinidad and Tobago saw itself gripped with the phenomenon of increasing statistics on crime, and in particular, kidnapping for ransom, grievous assault. The UNC opposition and the PNM government went at it. The PNM proposing restrictions on the right to bail, the UNC saying effectively, and I'm putting it quite simply, you will not get restrictions beyond sunset periods. Take a 3 months, another 3 months, take a 1 year. That short chain disappeared when the UNC came into office as a government in 2010. They immediately received the support of the PNM in saying, take a 5-year sunset period, increase the limitation against bail from 60 days where you can't get bail if your trial has started or not started, let me put it that way. They jumped to 120. They received full support. Why? The then PNM opposition said, you need support from a constitutional majority perspective to achieve these laws. So what happened in 2015 was that all the laws collapsed down. And in particular, the progression of the severity of lack of bail, which existed up to 2015, was effectively 3 strikes and you're out. That's the 1994 law. 2 strikes, you're out. Those are the periods under Anand Ramlogan as Attorney General. 1 strike, you're out. For certain offenses being grievous offenses, specified offenses as they were called in the second part of the second schedule. All of those severities which allowed law enforcement and allowed for the incarceration of the most severe criminals, all of that collapsed. And the law went back to 3 strikes, you're out. And let's explain what the 3 strikes, you're out involves. The 3 strikes, you're out. So under the Bail Act, Madam President, what time do I end in full time? Thank you. It's hard to do justice to this legislation in the time permitted, so I'll have to use a generous amount of constitutional addressing in my wrap-up. So let's deal with stats, let's deal with what the law is and why we want to change it. In the Bail Act, you can apply for bail. You have a prescription against bail under Section 5 of the Bail Act, which says, a court shall not grant bail to a person who is charged with an offense listed in Part 2 of the first schedule and has been convicted on 3 occasions arising out of separate transactions of any offense or any combination of offenses. In calculating that time, only those convictions recorded in the last 10 years shall be taken into account. Now that, quite frankly, to stand as existing law is an absolute nonsense. Let me explain why. If you are in jail for 5 years, or 7 years, or 10 years, how are you getting convicted for a second or third offense? In other words, then, it is nearly logically impossible for you to be denied bail because you've had 3 strikes whilst you're incarcerated. How are you going to get that? Unless, of course, you were incarcerated and there were other trials against you and you were convicted whilst you were incarcerated for those other matters, serving an existing sentence. So that law was, quite frankly, nonsensical. So nonsensical was it that the UNC agreed to amend that law and the PNM in their successive tenures, 2005 to 2010, and then 2010 to 2015. And we moved from 3 strikes to 2 strikes. We discounted the period for which you spent in incarceration. In other words, then, they took the 15 years or 10-year calculation periods for the time that you are actually on the outside, not whilst you were serving time. But what happens next in the schedule of offenses that currently exist? And that is to be found at the offenses set out as specified offenses at Part 2 of the schedule. We had trafficking in narcotics, we have trafficking in narcotics, possession using firearm, possession using imitation firearm, rape, sexual intercourse, buggery, shooting, wounding, robbery, larceny of a motor vehicle, burglary and housekeeping, arson, attempt to commit any of these, and receiving stolen goods. So that's what serious offenses look like. Quite respectfully, the government does not believe that receiving stolen goods, burglary and housekeeping, or larceny of a motor vehicle ought to have place in a schedule as a serious offense. We don't. We consider that only the most bloody crimes for which we can demonstrate statistics ought to be in that basket of offenses. So the bill, Madam Speaker, Madam President, proposes that we, first of all, amend Section 5. We're proposing that we repeal subsections 2 and 3 and that we insert a new subsection 2. If we look to the Parent Act at Section 5, we're removing effectively that 3-strike rule in subsection 2. We're removing the calculation, which was a nonsensical one, to say only convictions in the last 10 years will be calculated, because I've just reminded how insane that formula is. And we are inserting now a new subsection 2, which is admittedly stark and is the one that's going to challenge constitutional consideration. It is. Subsection 2, as we propose, the new one says, a court shall not grant bail to a person who on or after the commencement of this act is charged with an offense listed in Part 2 of the first schedule and has been previously convicted of an offense which is punishable by imprisonment for a term of 10 years or more. That says, if you have been convicted for a new formula of very serious offenses, if you have an actual conviction and you come before the court on a charge for the same type of matter, no bail for you. Question, is this clause in need of some amendment? Should we provide some filter to it? I look forward to the fulminations of the Senate here today, because I'll tell you, the government is anchoring a milestone for itself. This is not the law itself until we settle upon the law. Subsection 3 is where we treat with an introduction of something referred to, as I will put it quite simply, charge. Subsection 3 says, subject to 2, which is what I've just addressed, that's where you have a conviction and a charge. Subject to 4, which is where you can deal with it if you have a 120-day start of your trial or not. And 5, where it's 60-day trial for matters concerning, effectively, children under the Anti-Gangs Act. Subsection 3 says, if you find yourself before a court should not grant you bail if you are charged with an offense, firstly, something under the Firearms Act, that's Section 6 of the Firearms Act. If you have a pending charge for possession, So, first limb, if you appear before the court and you're charged with an offense under the Firearms Act under Section 6, and you have a pending charge for possession of a firearm, you ought not to get bail. So we're targeting firearms matters. Second charge arrangement, we say if you have something in Schedule 2, you have a charge for the bloody crimes in the second part of the schedule, and you come with a charge for another one of those, in other words, then you're charged for serious matters in the schedule, there ought not to be bail. And the last thing is we say if you have a charge for, again, a Part 2 offense, except under Section 6, where the prosecution informs the court and the person or any person involved in the commission of the offense had in his possession a firearm or imitation firearm. In other words, then, again, centering upon the use of firearms. So, that section is qualified by saying you should only not have bail for a period of up to 120 days. I remind that 120 days came from the UNC amendments in 2011 go forward. You should only have that position subject to a safeguard, which is in subsection 4. And it says, where a person is charged with an offense mentioned in 203 and brought before the court, but no evidence has been taken within 120 days, you can apply for bail. We take a further caution in subsection 5, where we speak specifically now about a person charged under the Anti-Gang Act who's harboring a child, and that person is in loco parentis, meaning you are acting almost as a parent to that child. You're a guardian or person with responsibility. We reduce that period down to 60 days. There's a further safeguard that says in subclause 7, for the purposes of this, that where the evidence was taken within 120 days, but the trial is not completed within 1 year, you can apply for bail. Let me translate this very simply right now. We are proposing conviction under the serious bloody crime schedule and a charge, no bail. Charge for the bloody crimes set out in Part 2 of the schedule and a charge for that, no bail. If you have a charge with a firearms matter and a further firearms matter, or you are using a firearm in the course or commission of a serious crime in the schedule, no bail. Safeguard, if you didn't start the matter within 120 days, you can apply for bail. Safeguard number 2, if you didn't complete the matter within 1 year, apply for bail. What is the rationale for this particular clause? The rationale is the statistical information available to Trinidad and Tobago, which I will go into now, and which I will circulate to members now. I'll ask my team to prepare the CAPA TTPS statistics for circulation. And also the historical information which appears in relation to when Trinidad was gripped with kidnapping for ransom. That information shows that a cooling off period brings results. Because effectively what we're saying is your worst case scenario is after 1 year, if your trial is not completed, you can apply for bail in the circumstances of subclause 3. What did the statistics tell us? Why do we want this? Let's start with the anti-kidnapping days, the legislation which drove the amendments 2006, 2007, 2008, and which were doubled by the UNC in 2011 go forward. What happened? In that period of time, kidnapping for ransom was a scourge in this country. Then Attorney General, firstly John Jeremy, secondly Bridget Anisette George, came to the Parliament and said to the Parliament, look, we need a cooling off period. And I'm putting it very simply. Give us this period of formulation and let's see what we can do with kidnapping for ransom. Kidnapping for ransom went to 0 in that period of time. It went to 0 in that period of time. We then went into the sobriety of reformulating the schedule. It went from that wider schedule, including larceny of a motor car and household breaking, etc. Those were removed and the more violent crimes came in. Intercourse with a child, kidnapping, the bloody crimes, all of which failed and fell in 2016 when the UNC refused to support the law. All of that was in the progression of sobering up the schedule of offenses, called specified offenses. But what do the current statistics tell us? The TTPS says, as at 7th May 2019, for their Crime and Problem Analysis branch, that's CAPA branch, firearms found and seized for the period, I'm taking a 10-year period, 2009 to 2019, in gross, 6,387. And we disaggregate them from revolver, pistol, shotgun, homemade shotgun, rifle, trap gun, flare gun, machine gun, submachine gun, other air rifle. And I'm going to take submachine gun alone. 43 submachine guns. We went from 0 submachine guns in the entire period 2009 to 2015. Not a single submachine gun. 2016, 0. 2017, 23. 2018, 14. 2019, 6. 43 in total. One submachine gun, as we have seen as a matter of fact in Trinidad and Tobago, sprayed into a crowd indiscriminately, killing children, killing fathers holding their babies' hands. We now have them in this country, honorable senators. Let's look to rifle. When we looked at the statistics of rifle in 2009, there were 2, 2010, 2, 2013, 7, 2016, 4, 2017, 34. 2018, 15, 93 in total. Let's look at shotguns. 2012, 51. 2015, 62. 2017, 83. 2018, 70. 629 in total. Pistol. Well, the numbers have always been fairly high for pistols. But let's look at 2009, 163 pistols. 2010, 161, 11, 150, 12, 185, 2018, 508. So we are seeing statistically a significant jump in firearms found and seized. Let's turn a little further. Report of firearm-related offenses. Listen to this one. In the period 2009 to 2019, 17,271 matters. In the following consequences: murder, 3,472. Woundings and shootings, that is murder gone wrong, 2,631. Robberies, 11,168. But when we look to the numbers, look at 2012. 2009, 2,500. 2010, 2,300. I'm talking the totals. 2012, 2,100. 2013, 1,482. 2014, 1,399. Notice the numbers going down. Down to 2018, 1,552. Why did we go down in particular in the period whilst the UNC was in power? Because you had a law to deny bail in these circumstances. We had a law to deny bail, and you had a commissioner you had a minister of national security, who is now a commissioner of police, quite incidentally. That minister of national security was fired by the last government for telling the truth in an allegation, and we now have this situation. I see Senator Choate express some concern, but I'm entitled to say it the way I see it. Arrests for persons of firearms, 2009 to 2019. If we look at the arrests, we have 5,391 arrests. In 2009, 360, 2010, 412, 2013, 410, 2014, 568, 2016, 673, 2017, 765, 2018, 804, numbers going up. We're arresting more people for possession of firearms. The aggregate number for that 10-year period, 5,391. Arrests under the Anti-Gang Act in 2011, 177, 2013, 3, 2014, 9, 2015, 16, 2016, 2, 2018, 1, 2019, 5, 213 in all. We look at arrests under the Larceny Act. We have a total for serious crimes 20,182, minor crimes 2,486 in that 10-year period. Arrests under the Dangerous Drugs Act, we have a total of 31,958 arrests. Again for the 10-year period 2009 to 2019. We have arrests under the Anti-Terrorism Act. There's only been one in 2018. That's in the period 2009 to 2019. So under the Anti-Terrorism Act, we actually have an arrest. One anti-terrorism matter is one too many, because you're talking about a very severe class of offenses. Arrests under the Trafficking in Persons Act for the period 2011 to 2019, there have been 9. And as you know, there are ongoing investigations with respect to a whole lot more. Arrests under the Kidnapping Act 2009 to 2019. Now, this Kidnapping Act is more than just kidnapping for ransom. It is kidnapping in general. For the period 2009 to 2019, there were a total of 840. But when you see the peaks at 2012 of 141, they begin to cascade down. 55, 66, 77, a peak up. 2016, 48. 2017, 76. 2018, 119. We're seeing that number and needle move. We've also provided arrests under the Forgery Act. We've also provided serious crime detection. In the period 2009 to 2019, the reported cases in 2009 were 22,000 odd, detected 3,854, 17% detection rate. We get up to 2018, we're looking at 13,445 with a detection of 4,558. We see the detection rate going up from 17, let's go 2009 straight through to 2019. The detection figures are, as a percentage, 17, 16, 19, 17, 18, 23, 23, 24, 31, 34, and that is for the period 2015, 23, 16, 24, 17, 31, 2018, 34. 2019, where we stand right now, 28 currently. So what I'm saying is detection is actually going upwards. We've also aggregated arrests for sexual offenses, and we have sexual offenses disaggregated by offenders who are 17 and under. For that 10-year period, there are 294 minors who have committed or allegedly committed sexual offenses. For those 18 and over, there are 3,356 for a total of 3,829. And we've also done arrests for offenses against the person. There are some 18,000 odd offenses. But I'll circulate these figures so that members can have their own view of these statistics. The point is that those statistics are grounded in what we propose in the schedule to the reformulated amendments as we propose now. We are asking in reference to the amendments to Section 5, which we propose in this bill by Clause 5. We are asking for this situation of conviction charge, charge, firearm and scheduled offenses, or firearm offenses in a charge relationship. We're putting that in relation to a schedule, and that schedule is comprised of offenses under the Anti-Gang Act, all over 10 years. Offenses under the Offenses Against the Persons Act, again with reference to an offense being over 10 years, except for 2 small exceptions. Offenses against the Dangerous Drugs Act, the Kidnapping Act, where there's a sexual offense in which the alleged victim is a child, under the Sexual Offences Act or the Children's Act, an offense against the Sexual Offences Act, Anti-Terrorism Act, Trafficking in Persons Act, firearms, and any attempts to commit those. So the schedule, which we label as Part 2 specified offenses, is a very serious schedule. What we are asking honorable members to consider is that, yes, we are proposing a fetter in the constitutional arrangement, but we are asking for it to be safeguarded by making sure that we do this only in relation to the most heinous and grievous of offenses as they are set out in the schedule. The data which I have just read out shows us, as it relates to firearms in particular, the phenomenon of submachine guns alone, the murder rate which is happening. When we look to these statistics, the country needs a bit of a fighting chance. Now, obviously, the argument is going to come out, well, why not just allow the Bail Act to go the way it does? Surely, Section 6 of the Bail Act, when you read it, tells a judge what factors ought to be considered. Surely, the consideration of the judge in coming up in the exercise of judicial discretion is well set out in the legislation. Why not rely on that? And one can properly say, yes, technically speaking, that law looks good. But what are we seeing now in a democracy such as ours based upon the statistics? We're seeing that wherever we utilized the restrictions against bail and allowed for what I will call the cooling off period, we saw a dip in the most serious crimes. So in our society, we have seen that the judicial exercise has not been as effective as it ought to be when it is left on its entire discretionary purview. Now let's get to some basic constitutional principles. The supreme law is the Constitution, so declared by Section 2. It is a fact that one must presume constitutionality. It is a fact that there have been dicta, and I will acknowledge it, in the United Kingdom, in Canada in particular, even in Trinidad and Tobago, where we have had considerations as to what constitutionality in restrictions upon the judiciary ought to look like. Yes, I am aware, I'm sure my learned colleagues will have done their research of the cases of St. Omer and Justin Stuart Charles in the Court of Appeal, in particular the dicta coming from Mr. Justice Gregory Smith, Justice of Appeal. Yes, we have the Ryan Reno Mahabir versus the AG matter, which is currently on appeal. And yes, we also have the classic statements, I'm sure Senator Choate would be well aware of these. I believe she appeared in these matters, of Steve Ferguson and the Attorney General, those matters which set out the clear parameters of constitutionality, the interruption of the tripartite arrangements between the judiciary, the legislature, and the executive, the separation of powers argument. But quite simply put, when we come to test this law, the question is going to be, where do we strike a balance based upon the data? Now, we can go at this tit for tat, opposition saying one thing, government saying one thing. I can stand up here, I've come prepared to read out all of the excerpts from all of the members, Mrs. Prasad Bisesa, Anand Ram Logan, Dr. Munilal, as they appeared in the iterations of office that they held in the period 2010 to 2015, and they will show exactly the same arguments being offered today as to factual ground basis. What we will see different is that a PNM opposition agreed with the government. And that is what is going to be challenged today. What we have statistically, and I'm going to the Section 13 argument of the Constitution, beyond the 3/5 numerical factor, do we demonstrate that a society such as ours, the idiosyncrasies of our society, the good, the bad, and the ugly of our society, do they demonstrate a need, based upon statistical information, for us to cause this kind of law to be developed? And my simple submission in relation to that is yes. And I propose to do a very fulsome constitutional answer in the wrap-up to this debate, because that's a whole argument by itself, and I'm confident that that's what I'll be met with in the course of this debate. So let me reserve my position to answer those positions, because I think that we have ground to do that. Do we think that the law may be in need, as proposed, may be in need of some amendment? Can we come up with a formula here today in the Senate? Perhaps we can. Perhaps we can. But the question for our country, for those looking on, is where do we strike the balance? When do we give the fighting chance back to the country? Where in the circumstance of having submachine guns in Trinidad and Tobago do we get that? Now, let me just segue for a moment. We are grappling with an economic migration issue for our neighbor which is closest to us, where there are circumstances that the government is attempting to manage. It is a fact, having spoken with the Commissioner of Police today, that we have had a serious uptick in certain of the crimes as a result of some of the immigrant issues. And the Commissioner can speak to that for himself, but suffice it to say, the numbers of murders have been noticed to have risen as a result of some of our migration issues. I'm not talking only about Venezuela, I'm talking about other positions. So our state and condition of Trinidad and Tobago must be factored by the porosity of our borders. We do not have offshore patrol vessels patrolling our waters. That boat, or rather those 3 boats, sailed to Brazil and are now in the Brazilian Navy labeled as Trinidad-class vessels. Whose decision was that? That was a decision of the last government. In any event, it's a fait accompli. The fact is we don't have them. So we're dealing with being an island, 2 islands comprising a state where our borders are under challenge. We're dealing with arms and ammunition coming in from outside of our jurisdiction. We're dealing with the prevalence of submachine guns, shotguns, and rifles where we had none in the period prior to this tenure right now. We're dealing with the indices of success in kidnapping for ransom and in dealing with the cooling off mechanisms that no bail conditions gave this country in the period 2006 go forward. So that's clause 5, which is the heart and soul of this legislation. I'll accept that the Canadian jurisdiction has what I would call the show cause position, where there's some degree of balance as to simple blanket restriction or not. But let's turn quickly to the other amendments. There are simple ones. We must now factor the intended abolition of preliminary inquiries, and therefore the fact that a master can also consider issues of bail, as we've dealt with the jurisdictional blending for those positions. It may be that we need a small amendment to return the justice of the peace, because justices of the peace can operate under the magistracy. So that may be a small tweak that we would be required to do here. We are harmonizing the fact that we no longer have children being persons under 14 years of age, minors or older minors. So we're just referring to children as children, of course, in the legislation. But clause 6 is where we simply do the amendment to part 2, substituting the schedule. And very importantly,
Attorney General, you have 5 more minutes.
Thank you, Madam President. Very importantly, clause 7 is the one that gives a very important constitutional measure. What is clause 7? It is all of 1.5 lines long. It says this act shall continue in force for a period of 5 years from the date of its commencement. This sunset clause is an important redress because it means that the law will not be in perpetuity. It will have the ability of being reviewed. If there's no consensus for review, we can have another go at it. And there are circumstances proven only by the UNC where you could give no support for something which you've done on 4 occasions yourself, a UNC government, give no support for that which you offered into prosperity and let it collapse, as happened when the bail amendments collapsed in 2016. So, Madam President, we have a serious issue before us today. Quite simply put, are we prepared to say no bail in certain circumstances? Do we want to qualify that right? I welcome the views of the Senate. Are we prepared to go to 1 strike? You have a charge on top of a conviction for the same category of bloody offenses set out in the schedule. Raping children, kidnapping people, attempted murder, trafficking in persons, dangerous drugs. Conviction and charge. Charge. You're in a situation where there are serious charges against you. Yes, of course, there are the dynamics as to whether one could be put upon an unfair charge. That has been a risk since policing and the constabulary was established in the United Kingdom and imported here. Do we want to consider the central focus upon firearms? Do we ignore the porosity of our borders? Do we look to the migrant issues that we're managing? Do we look to the uptick in crimes? Do we look to the actual confirmed existence of submachine gun and machine gun killings in this country and ignore it? Do we as a Senate today send a message as to what the legislature is prepared to do in its role and function in defending Trinidad and Tobago? We have become immune to killings in this country. People flip past the news, who died, who didn't die, who got shot at. You look at a child holding a father's hand who has been murdered in machine gun spray fire while they try to get somebody else. And some people for a moment say a prayer, shed a tear, but they turn the page. Because it's not me, it's not my family, not my child. Well, today, honorable senators, we're on test. Today, we decide where our constitutional, moral, legal parameters and methodologies lie. We can make the law. The government does not propose in the amendments before the Honorable Senate something which is cast in stone. This is a hard issue to grapple with constitutionally. I understand, as the advisor to this government, what the parameters are and how it will be tested. I genuinely understand it. To the opposition, I say in anticipation, try something other than the same old, same old. Don't hit me the constitutionality, because you know what? I'll read all your words back to you from 2010 to 2015. Don't hit me the can't trust this government, because we could have said it about you. Let's today put aside partisan politics. Let's today understand we have an opportunity in the Senate to send a message. Because you know what? If this Senate says that it's prepared to pass, the House may perhaps take notice. So, Madam President, this law attempts to be proportional. This law can perhaps be better managed, depending upon submissions coming, where we cast the balance. The issue is really narrow. What is the qualification to the fettering of judicial power? That's the issue. Where do we find that balance? How do we send the message to the judiciary? Do we want a cooling off period? We're attempting proportionality. Proportionality is on the back of statistics. Our statistics are terrible. I urge the Senate today to give fulsome measure, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Senator Hosein.
Thank you very much, Madam President, for giving me the opportunity to join this debate on an act to amend the Bail Act, Chapter 460. And Madam President, this Bail Act is not very unfamiliar to this Parliament, neither is unfamiliar to the courts of Trinidad and Tobago, because on a daily basis, this act has been applied throughout the length and breadth of Trinidad and Tobago with respect to granting persons their constitutional right to bail. And, Madam President, I saw that the Attorney General had left the chamber, but he started off on a very light note that there may have been a migrant problem in the constituency of San Fernando West last night. But, Madam President, the persons of San Fernando West are also complaining of that migrant problem, because their Member of Parliament for San Fernando West has migrated out of San Fernando West since September 2015.
Blow for blow.
And the Attorney General had a lot of issues when he raised this bill, and he admitted that there will be constitutional challenge to this bill, because the certificate to this bill, it requires a 3/5 majority, meaning the support of the opposition,
and or the independent senators, and then when it reaches the other place, it definitely requires the support of the opposition. And Madam President, the Attorney General said that when the UNC was in government, that the bail bill that we passed at that time helped reduce crime. But, Madam President, he also gave another example that when kidnapping for ransom was high, certain amendments were made to the Bail Act. And this was anecdotal evidence the Attorney General was given because it was not based on any study, it was not based on any analysis of the data. So I had to look at the Crime and Violence in Trinidad and Tobago IDB series on crime and violence in the Caribbean by Dr. Randy Sipasad, who's a criminologist. And they would have said, Madam President, that there would have been a decrease in kidnapping around 2005. But this was as a result of preventative approaches taken to stop crime, whereas suppressive measures, aside from their potential deterrence function, come into effect only after crimes have occurred. The criminologist, Dr. Sipasad, went on to say that there has been a progressive approach to criminal control in recent years. An example is the adoption of a restorative justice approach by the Ministry of Justice. Do you know who implemented the Ministry of Justice, Madam President? It was the United National Congress government that introduced the Ministry of Justice. So they are saying in this report, Madam President, that it was preventative approaches. It was resources being given to the police, resources given to the DPP's office, resources given to the judiciary that accounted for the decrease in crime at the time of the UNC government. It was not law alone. Because they said, Madam President, that it is evident that much of the legislation that has been developed or is in development is suppressive in nature and focuses on increasing penalties and criminalizing a wider range of behavior. It went on to say, Madam President, that the legislation was not the end-all of the matter. There must be other things to accompany the legislation for it to become effective in Trinidad and Tobago. And the Attorney General also sought to justify the denial of a constitutional right of bail based on the statistics. But I was listening to the Attorney General when he said that the anti-gang arrest, in 2011, it had about 200, and then it reduced to about 2 or 5 now. Then what is the rationale? If there's a reduction in the amount of arrest for anti-gang offenses, how can you come to this House and say, well, you need this bail bill to deny bail for those offenses? Madam President, when you're passing legislation with a special majority, there must be proportionality. You are denying a right, but you must have a legislative aim to reduce something. If it's already reduced, Madam President, what is the rationale for the introduction of no bail for those offenses? Anti-terrorism again, one arrest. Madam President, the Attorney General will say he accused us that we are not going to support this. And from the outset, I'm going to say we are not going to support this arbitrary, capricious, dangerous matter that is in violation of our Constitution. No support to this. Madam President, at a time when we were in government, the United National Congress was in government, the legislation was well intended to reap certain rewards. It was tested, Madam President. A sunset clause was introduced. If you get no result from something that you amended, that you introduced, why are you going to re-implement this with no result, Madam President? There clearly can be no sense to this approach. It's a nonsensical approach. And the Attorney General, when he winds up, he will belittle us. He will say that we are the cause of crime, that give the police a fighting chance, Madam President. It's simple, you know. If the Attorney General wants to pass this bill and they need a special majority, let us go to the poll. Let the PNM try to get a special majority, Madam President. Let us go to the poll. If you want that special majority, let us go to the poll. But it is playing politics with crime. And I would say this, Madam President, because the Attorney General knows that we are not going to support this. because this was a measure that they attempted to introduce sometime in 2016. And we, from the outset, indicated that we were not giving any support to the suppression of the rights, the constitutional rights of the citizens of Trinidad and Tobago. But I want to quote, Madam President, because that bill in 2016 is very similar to what we are doing here. And the Hansard is the 1st of July 2016, where the Honorable Leader of the Opposition quoted from the Prime Minister. And this is what the Prime Minister had to say. So who is the bright brain who drafted this? He's talking about the bail bill. It has to be somebody who knows absolutely nothing about what the existing law has in it. Who would have drafted this and get the government to come back to Parliament to waste Parliament time? Madam President, something is happening. The same thing is repeating itself, trying to make unbailable what is already unbailable. This is the opposition leader.
Specific about what the times, the dates that you're making all these quotations from. All right, you need to put it into, you need to specify when these statements were made. So for the record, please.
Madam President, I'm reading the Hansard of the 1st of July 2016, please. And it was the opposition leader quoting from the Honorable Prime Minister here. And this is page 52, please, Attorney General. And the Prime Minister, the then leader of the opposition, the Honorable Keith Rowley, was saying that I am putting you on notice now that you are walking the same road because I do not know who would have drafted this and caused you to be coming here to support it. I am putting you on notice now that you are walking that same road because, sorry, as we have said, you all could not be serious. You could not be serious because, for a start, most of it does not make any sense. Secondly, we told you we are not supporting it, but you want to hammer us home.
Senator Hosein,
yes, please.
Please. You're quoting from the leader of the opposition in 2016, who is apparently quoting from a previous statement. Is that correct?
Yes, please.
All right. So you've made the quotation, but it is confusing, and therefore I would ask you now, you can't be quoting at length in your contribution. So can you move on now, please?
Yes, please, Madam President. And Madam President, the point is that at that time, the opposition leader said he's not going to support the legislation. You're wasting time. And I'm going to say the same thing, that this government, this PNM government, has come to the Parliament to waste the people's time, Madam President. Because when this bill doesn't pass, you know what they're going to do? They're going on a public campaign to bad talk the UNC, blame the UNC, and blame Kamala as always. That's their mantra. That's what they hope to achieve in order to go back into government. But the people, the eyes are open. The wool has been removed over the people's eyes, Madam President. And I want to ask, firstly, this is a very important bill that touches constitutional rights, the right to liberty and the right to bail. Who was consulted with this bill again, Madam President? I would like to know, because the Attorney General normally, when he pilots a bill, he will give us a list of stakeholders who his office reached out to. Madam President, I would like to know who was consulted on this particular bill that is before the Senate. And you are repeating the same thing over and over and over again. Now, in the last incarnation of this bill, which is very similar to this bill, with the denial of bail for 120 days, I would like to have known how many cases were filed and persons denied bail for that period. I would also like to know how many of those cases were started within the 120 days. I would like to know what are the reasons that those cases did not start. I would like to also know if the police has been trained with respect to the application of this law, because this law is very arbitrary. As long as the police says, as I say so, as long as the police says that you have committed an offense with the use of a firearm, all he has to do is inform the magistrate. Madam President, you know that you are denied bail for that period of 120 days. Very, very arbitrary. I would have thought that since 2014, that this PNM, then opposition, now government, would have come in 2019 with something new. But it seems as though that they're just reenacting everything that the UNC does. Madam President, where's the creativity? Where's the holistic plan to deal with crime and criminality in Trinidad and Tobago. And the Attorney General did say that I would have mentioned the case of Daniel Santomir and the Attorney General, and also the case of Justin Stewart Charles against the AG. And that is CV 3475 of 2015, Madam President. And Justice Gobin, she examined, Madam President, the legislation. She examined the legislation and she found that it had been unconstitutional. I'm saying that the Attorney General is anticipating me, that the Court of Appeal did overrule Justice Gobin. But, Madam President, I believe that the matter is now before.
Could you put it a different way? Could you just say the Court of Appeal has overruled the decision? And let's not personalize it with the judges and that. Could we just leave it like that?
I'm guided. That the decision was overruled. And, Madam President, I believe that the matter is before the Privy Council now. I stand to be corrected. So I don't know why, Madam President, that we are rushing this without a final decision on this matter. Because let's just say the Privy Council comes back and says that the legislation is unconstitutional. What happens? It is the public's purse that is going to be damaged. What is the haste? Await the decision of the final court of this land, because we have seen many decisions in the past, Madam President, where the High Court would have ruled, the Court of Appeal will have ruled another way, and then the Privy Council would have agreed with probably the first instance judge in these circumstances. Yes, please.
Thank you for giving me. It's very gracious of you. You do accept that the St. Omer case is now in respect of law which fell, right? So it's academic. So the law that is going to the Privy Council is on an academic issue for law that lapsed in 2016. So there is nothing to come from the Privy Council because that law doesn't exist.
I understand that, but at the same time, the Privy Council is going to examine the exact same constitutional points that touches and concerns this bill. Academic or not, it will assist in whether or not, and it will help us in drafting proper legislation with proper guidance from the Privy Council. And, Madam President, Justice Gobin, in that judgment, did acknowledge the fact that there's so much legislation already. Why it is that we are passing more legislation? And if you would allow me to quote, Madam President, this is what Justice Gobin has to say. She says, as the bail law stands, Section 6 allows for judicial consideration to refuse bail in the case of repeat offenders or persons likely to commit another offense, similar to what we have here. If they are gang members or suspected to be because of their association and social ties, if they are persons who are likely to tamper with witnesses and interfere with the administration of justice. Regular factors in which the court will consider in granting bail. This is what she says. She says there is enough law on the statute books. A judge is saying this. Madam President, what may be required for this to actually work to protect the public and the administration of justice in the way in which it was intended, it is a serious shift in the way objections to bail are dealt with on the part of the police or prosecution. So here we are saying that the court is giving guidance that there may be some more training with respect to the objections being made by the prosecution. The implementation requires the police and prosecution to do the work that is required of them. This contemplates full and fair investigations into the background of accused persons, and more importantly, proper reports on the strength of the evidence of the accused having committed the offense. And, Madam President, that goes back to the provision in the Bail Act, in the Bail Bill, that deals with that an offense is committed, alleged to be committed. A person is charged, appears before the magistrate. Police informs that this person committed an offense of larceny. But while they were in the commission of the offense, all the prosecution has to say is that a firearm was used. You are denied bail. No firearm has to be produced. No ballistic report has to be produced. No other forensic report has to be produced, Madam President. There need not be any evidence of a firearm in the commission of the offense. And this person is going to be denied their constitutional right to bail and their constitutional right to freedom based on what? The say-so of a prosecutor? Madam President, we all know that there have been questions raised with regards to the quality of evidence given in this country with regards to the prosecution of criminal matters. And I think at this time, especially from recent events, it is very dangerous, extremely dangerous to give the police this power at this time, Madam President. It is very dangerous because we must not make law in a vacuum. We must make law having regard to our circumstances, Madam President. Must have regard to our circumstances. And there must be some sort of holistic approach when we deal with crime and criminality. This bail bill is not the be-all and the end-all of the matter. And the Attorney General did quote from the statistics of the detection rate. And yes, the detection rate may have increased. 2012, it was 17%. 2013, it was 17%. 2014, it went up to 22%. 2015, 22.8%. 2016, 23.6%. 2017, 29.8%. This is from the police service, a press release by the Commissioner of Police, Commissioner Gary Griffith, Madam President. And this detection rate is still unacceptable, Madam President. Totally unacceptable. Why it is that we are accepting complacency? Why it is that we are giving the police all of these powers when crimes are not being detected in this country in the way it should be? Having regard to the resources and the monies already allocated to the Ministry of National Security, we should have had a detection rate of 80% and excess, Madam President. This figure of about 20 to 34% is totally unacceptable. Totally unacceptable. The murder rate, the murder toll today, I am told, is about 220 murders already for the year. And then also the Attorney General spoke about securing the borders. Because this bill seeks to deal with the influx of firearms. It seeks to deal with firearm-related offenses. But, Madam President, you would appreciate that if warm bodies are being trafficked into this country, imagine how easy it is to traffic firearms and ammunition into this country. This government, this incompetent government, has allowed the borders of this country to be porous, Madam President. They boast, Madam President, that they have won 11 elections or 12 elections, but the borders are still porous. 4 years, Madam President, and all of the vessels, Madam President, most of the vessels are not in operation, the Coast Guard vessels. And then comes to this population to come and bring reactive pieces of legislation, arbitrary pieces of legislation, capricious legislation, push it down the throat of the parliament, push it down the throat of the opposition, try to bully us and then attempt us to support this. Madam President, we will not support this legislation. We will not support it. And I will say that on the backbone of statistics also, because I want to have the opportunity to quote the statistics. Because you know who will be implementing this legislation? It is the police and the court. I'll get to the prison afterwards. Let's look, Madam President, at the criminal indictments filed. But before I go there, I'll just refer you to the clause of the bill that I want to deal with. And this deals with, Madam President, the clause in the bill that talks about this here with regards to when evidence has been, a person is charged. This is subsection 7 of clause 5. It reads, for the purpose of this section, except section 3A, where a person is charged with an offense listed in part 2 of the first schedule, and evidence has been taken within 120 days of the reading of the charge, but the trial is not completed within 1 year from the date of the reading of the charge, that person is entitled to make an application to a judge for bail. So what that means? That means a person is charged, they deny the bail for 120 days, evidence has subsequently been led, but the trial has not been completed within the 1 year. They are allowed to apply for bail after 1 year. And Madam President, I take it, I will seek clarification from the Attorney General at his wind-up that this trial would mean a high court trial, because a preliminary inquiry, a sufficiency hearing, is not a trial. So that means that I have to wait for the completion of my matter at the High Court, you know. Let's look at how the High Court disposes of matters in this country. So this is a person who and that section I read is related to no bail for persons who have been charged with possession of firearms or ammunition. Now let's look at how they deal with matters in the judiciary at the High Court level. Firearms matters.
What are you reading from?
I'm reading from the Judiciary Annual Report 27, 2018 at page 28, Madam President. When you look at the type of matter, I'm looking at firearms, the time of disposition. You know how much matters were disposed that was of antiquity of less than 1 year? 4. 1 to 2 years, 0. 2 to 3 years, 2. 3 to 4 years, 0. 4 to 5 years, 0. 5 to 6 years, 1. 6+ years, 5 matters. 5. So you are telling me that a person can be denied bail up to a time of almost over 6 years if they are charged with possession of firearms and ammunition in this country and they have no right to bail, Madam President? That is absolutely ridiculous. The time that they spent on remand may very well be the period of sentence that the court would have given to them. And that is the reality of what is happening in this country. So how can we support legislation like this when we are effectively denying a person their right, their constitutional right, for a period of how much? Over 6 years, Madam President. That is absolutely, absolutely unacceptable. And do you know where these persons who are in remand, the conditions of remand, Madam President, the courts have said it. We have the case of Colin Edgehill, Antonio Sobers, Scott against the Attorney General, Sean Wallace. All of those cases dealt with the conditions of remand. You had in Colin Edgehill, Madam Justice Gobin. She described the remand yard as a hellhole. We are putting persons in the hellhole, Madam President.
I take it, Senator Hosein, that you're completely ignoring my guidance that I offered to you a little while ago in your contribution. I take it you're ignoring it.
No, sorry, Madam President, I'm guided. And Madam President, that judgment would have described the remand yard as a hellhole. But we had the solution. You would remember in 2012, in order to try to alleviate the overcrowding of the prisons, because, Madam President, the prison system is bursting at the seams. You would have had recently a prison break where prisoners would have been roaming this country, helicopters crashing, Madam President, in this country. We discovered subsequently that the air guard is not in the best shape. But we attempted in 2012 to address this situation. We passed the Electronic Monitoring Act, 2012. 7 years have gone, Madam President. 7 years. And we don't, up till now, in this country, have electronic monitoring bracelets. What is going to happen with the prison officers in the prison when there's overcrowding? There's already so much violence in the prison. Prison officers are crying out for better working conditions, Madam President. And what you are going to do, just encourage more and a higher prison population, overcrowding, breaching persons' rights. We are completely ignoring our international obligations. And that is the effect of this bill. It is effectively because I can't deal with the situation, the court system in a mess, the police are trying, but you know what? We'll just lock up all Ali and put Ali in a jail. That can never, never in any democratic society be the solution or sensible decision of any government. Then we look at the Forensic Sciences Center, because this center has a critical role to play with regards to the implementation of this legislation. When you look at the Forensic Science Center, if a person has been charged with a firearm, you would realize that the charge will be read that it's something resembling a firearm, Madam President, until a forensic report certifies that the device is actually that of a firearm. In this country of Trinidad and Tobago, after millions of dollars has been thrown to the Ministry of National Security, would you believe that a ballistic report takes almost 2 to 3 years? 2 to 3 years, Madam President, to be presented in a court in Trinidad and Tobago? That is absolutely unacceptable. And persons who are caught under this new legislation, persons who are caught under the new legislation at Clause 3A, Clause 5, subsection 3A, which says that persons who are charged with possession of a firearm or ammunition or prohibited weapon, no bail. Even if your trial starts, even if evidence is led, your trial, you are denied bail, Madam President. And then you will have to sit there waiting for 2 years to 3 years to say, well, we now are going to collect the ballistic report from the Forensics Science Center, Madam President. That is what this bill is doing. And you would also have heard in a previous debate, I believe it was last week, and I think this is a very important issue that we need to raise, Madam President, that the Attorney General would have said how much it cost this country to house a prisoner. I took this document, Madam President, from the Ministry of the Attorney General. It was a slideshow presentation given on the reform of the prison service. So this is a document that was presented by the Attorney General. And it says the estimated annual cost of running the prisons only, is $596 million. That's 2015. And these include manpower at the prisons, electricity, water, food, transportation. There are additional monetary factors in the maintenance of an inmate, such as the expenses related to the cost of administering of the criminal justice system with judicial, prosecutorial, and policing services and witness protection. As of December 2015, there were 3,667 inmates in prison with 2,235 on remand. Now, I would ask the Attorney General if he can give us some updated figures with respect to what the 2019 prison population is. It says that it is estimated that with the inclusion of additional expenses, it may be extrapolated that the average monthly maintenance cost for an inmate could be $20,000 to $25,000. $20,000 to $25,000, Madam President. And we look at the average length of time a person spends on remand. This is at December 2015. Length of time, more than 10 years. Percentage of inmates on remand, 11%. Estimated cost of maintaining one inmate over the length of time, which is more than 10 years, $2.6 million. Estimated cost of maintaining inmates over the length of time extrapolated, $649 million. That is for 246 inmates over 11 years. More than 5 years, 19% of the prison population. Estimated cost for 6 years per inmate, $1.4 million. 5 years or less, 70% of the remand population. 5 years, it costs the taxpayers $1.2 million. So, Madam President, are we really dealing with the situation? Having regard to our economy, this is an extremely bad decision. All of this money that we are using, maintaining inmates at the prisons, Madam President, could be used towards the police service. It could be used towards building courtrooms. It could be used towards outfitting additional courtrooms, Madam President. It could be used to hire additional prosecutors, hire defense counsel through the legal aid system. Madam President, these are the solutions to the problem. It could also go and attribute towards the maintenance, the restructuring, the reform of the Forensic Sciences Center, because that is a very important institution in the implementation of this legislation. But the government, and I'm quoting from a 17 August 2017 article from Luke TT, where it says that government approves $53.6 million for remand prison upgrades. And this was in 2017, Madam President. We're in 2019. Where are the reform? Where's the reform to the prison, the remand system, Madam President? Where is the reform? This is a government of announcements. They're always doing, and do nothing. They always do nothing, Madam President. They always do nothing. But I want to I know my time is limited, and I want to get specific into certain issues I have with regards to certain clauses of the bill. And let me start with Clause 5, which amends Section 5 of the Act. And at subsection B, it says that a court shall not grant bail to a person who, on or after the commencement of this Act, is charged with an offense listed in Part 2 of the first schedule and has been previously convicted of an offense which is punishable by imprisonment for a term of 10 years. So, person convicted of an offense that carries a penalty of 10 years or more and is now charged with a scheduled offense in the Act. So, conviction and charge. Madam President, Mr. Vice President, sorry. Mr. Vice President, under the Dangerous Drugs Act, there's an offense called trafficking. And if a person has in his possession 1 gram of marijuana, cannabis, but he is found near a certain radius within an educational institution, Madam President, that 1 gram of cannabis, marijuana, will be regarded as trafficking. So you have 1 gram. Then if a person is in possession, not close to a school, but he's possession of less than 1 kilogram of cannabis, he will be charged for possession. But possession carries, it doesn't carry a sentence or a conviction of 10 years. Trafficking does. So let me make it clear. The offense of trafficking, 10 years, possession is less than 10 years. So the person who is charged with trafficking will be captured under this particular clause. Madam President, Mr. Vice President, where is the justice in this? A person with 1 gram of marijuana as compared to a person with 1 kilogram. This section needs some rethinking, Mr. Vice President, with regards to how it is drafted, because it can lead to certain injustices with regards to the system. I know the Attorney General is on a campaign with regards to whether or not the government policy will be that of the decriminalization of marijuana. But this section, Attorney General, I think you should have another look at it with regards to the offenses that carry a term of imprisonment for more than 10 years. There may be some qualification that can be placed with regards to that particular clause, if you accept. Then, when you look at subsection 3 of clause 5, and I'm looking at particular B, where, subject to subsections 2 and 4 and 5, a court shall not grant bail to a person who, on or after the commencement of the Bail Amendment Act 2019, is charged with an offense listed in Part 2 of the first schedule and has a pending charge for an offense specified in the same schedule. So, this is a person who has been on bail, he allegedly reoffends, he has a pending matter plus the current charge. Madam President, you would... Okay, thank you. You would see, Mr. Vice President, that with regards to the seriousness of the offenses, here, we look at anti-gang legislation, offenses against the person, Dangerous Drugs Act, kidnapping, sexual offenses, anti-terrorism again, trafficking, firearms, and any attempts to commit those offenses. Madam President, Mr. Vice President, you would see that some of the offenses listed in the second schedule may be less serious, may be more serious than offenses that are listed in the, with regards to the 10-year. So there may be some engineering that has to be done with regards to that particular section, because it can also lead to some injustice with regards to how that section is applied, Mr. Vice President. But I want to say absolutely that clause, subsection 4 of the bill, I cannot support at all with regards to the denial of bail for the 120 days, because we have tried this in the past and it did not work. With regards to subsection 7 of the bill, again, this was tried with regards to the evidence being taken and effectively denying a person bail for possession of firearms until a trial is completed. Again, that is not something that can be supported unless the judiciary has a way in which these matters can be disposed of in a very expeditious manner. With regards to the sunset clause, for a period of 5 years, Absolutely not, Mr. Vice President. We cannot agree to persons' rights being infringed for such a long period of time. Again, we admit, Mr. Vice President, we have tried this legislation as a government with good intention, but we did not reap the rewards that was expected with regards to the implementation of this legislation. And I ask the government to take heed. I ask the government not to repeat an error that was probably made in the past. I ask the government to come here with good sense, Mr. Vice President, because we have seen in this parliament, as of recently, a trend, something that is very sacred to all of us, which is the Constitution. At Section 1, it speaks of Trinidad and Tobago being a sovereign democratic state. At Section 2, it speaks of the Constitution being the supreme law. But as of recently in this parliament, Mr. Vice President, we have seen legislation being introduced that effectively curtails the rights, the freedoms, and the privileges of ordinary citizens of Trinidad and Tobago. There's a trend, Mr. Vice President. It is a growing autocratic dictatorship, Mr. Vice President. It is the PNM, this is their final leg of their legislative agenda, Mr. Vice President. It is the death of democracy in Trinidad and Tobago. It is the death of democracy. And we on this side are not going to stand for the rights of the citizens being curtailed or taken away. We want to have the right to access information from this government. We want to ensure that the right of bail is preserved to the people of this country. We want to ensure that persons are given the liberty and the freedom afforded to them under this Constitution, Mr. Vice President. We will stand for no less. And I plead with this government, and we demand on this side, Mr. Vice President, that this bail bill that is before the Senate be withdrawn forthwith, Mr. Vice President. And I thank you.
Senator Vieira.
Mr. Vice President, I remember a time when we didn't have burglar bars in our homes and in our businesses. I remember a time when you could leave your car with the windows down and not feel intimidated or unsafe. I was away last week, and how refreshing it was to just be able to walk about at any time, in any place, and not feel threatened. We have lost so much. This country has suffered, and it no longer feels safe. It is incumbent on us to change it and to reclaim civil society. This is a short bill, but it may have dramatic and profound effect in that it will get alleged shooters off the street. We have a scourge of illegal arms. As we know, because of what's been happening in Venezuela, arms are often used as a bartering tool to get access to all kinds of things. Arms have been used hand in glove with the drug trafficking trade. Arms have filtered into our society, and they are, in fact, a scourge. When I reflect over the past year, looking at the television, how many times have I seen weeping mothers, a young man learning to drive, shot by a stray bullet, a young girl walking about, killed by a random act of violence. Enough is enough. The innocent lives lost cannot be brought back, but we can definitely do something to stem the tide. There is no right to bear arms in Trinidad and Tobago. And it's true, citizens have a constitutional right to be presumed innocent and to be granted reasonable bail when charged with a criminal offense. And those fundamental rights, those constitutionally guaranteed rights, may only be curtailed or taken away by Parliament for just cause. So, is there just cause? I think the carnage on our streets the illegal gun trade, the gang wars, the weeping mothers. That constitutes just cause. And while Senator Hosein made some very good points, I think he missed an important point. If there is no firearm involved, no issue arises. The short answer is we should make it clear to all the bad boys out there on the streets. Lay down your arms. Civil society, this parliament will not allow you to carry guns, to carry illegal arms, to engage in these armed offenses. If you do, there will be dire consequences. We must be serious about this. Singapore is a democratic society, but they do not tolerate criminality. We have to draw the line. There have been too many weeping mothers, too many senseless deaths. The bill is tempered. There's a sunset clause of 5 years. You're not denied bail indefinitely. After 120 days, you can go back to a judge in chambers and seek to have bail granted. The accused has to be charged with a serious offense. We as a parliament can abrogate the right to reasonable bail where it's for the peace, order, and good government of Trinidad and Tobago. Now, I recognize that there's a palpable tension between the needs of society and legal ethics. There are competing needs and ethical principles involved. On the one hand, there is a need to save lives, and maintain peace and order in society. The principle of utilitarianism places the welfare of the many over the few. And on the other hand, we recognize that such reasoning can sometimes be morally dubious, where it undervalues the rights of the individual in the process. So I'm not being glib here. In legislation of this nature, we need to be mindful of the conflict between the rights of the individual and the needs of the wider society, group interests. No one wants to undervalue the individual's rights. So careful reasoning is necessary, and we do have to do some work on this legislation. To assume that everyone accused of unlawful possession of guns or ammunition is a criminal or a menace to society would be a fallacy. Among other things, it ignores the possibility of people being framed or otherwise wrongfully accused. There is a danger inherent in tarring everybody with the same brush, where fundamental, and that is further compromised when fundamental human rights are curtailed. In this instance, protection of the law, presumption of innocence, right to reasonable bail. This legislation is really about detention without trial. It's internment. And as much as I see the need for it, and as much as I want to support it, I am torn because I'm also aware of just how easy it is to frame someone and how difficult it is for an innocently accused person in such a position. And I'm not speaking now from theory. In February 1987, I successfully defended someone who had had a gun planted in and around his premises. And a tip-off informed the police exactly where to go. And not so long ago, another client of mine was the victim of a similar tip-off, and this time involving drugs. If you want to destroy someone's life and reputation, or just get them out of the way, framing them is a relatively easy thing to do. And the effect of this legislation is that we are taking away the court's discretion. So it's incumbent on us to provide some sort of offset, some antidote, some way to redress the balance when that type of evil occurs. As it stands, the current laws don't really do much to help. Relief is tangential at best. Malicious prosecution, making false police reports, entrapment, not enough. We need to up the ante so that anyone who is the victim of a framing up will face dire consequences. So, Mr. Vice President, I have circulated an amendment. I'm bringing an amendment to deal with that, but let me say up front, I don't want my amendment, which will be to introduce an offense for framing, to derail or torpedo this bill. I'm quite prepared to allow that. What I would ask is that you consider the amendment, and it may be that it is better brought in the Evidence Amendment Act, but I do think we need to have that looked at seriously because, as you know, I don't want to say elections and politics, but all kinds of frame-ups occur for all kinds of reasons, from embattled spouses to law enforcement taking shortcuts to people saying it's politically expedient. I think it's an offense we need to consider. And the effects of a frame-up are dire. You not only lose your job, you lose your reputation, you have to go and fight contentious criminal proceedings, there's a risk of fine, imprisonment, and also a conviction on your record. So, you know, it's not enough to say that the Bible commands that thou shalt not bear false witness against your neighbor, and that's a breach of the 10 Commandments. Evildoers will take on the Bible, and so we need to do more, hence my proposed amendment. But I agree with the Attorney General. Our bail legislation has gone around in a very circuitous way, in a very convoluted route. This legislation is a step towards clarifying and making the law easier. I also agree with the Attorney General, and I accept that when dangerous criminals are off the streets, crime goes down. The statistics relating to firearms found and seized, and firearms-related offenses, murder, shootings, woundings, robberies, these are alarming. We cannot ignore what is in front of us. We must do something about it. The accused persons under this bill are not going to be denied bail indefinitely. The law has a sunset clause. And as I like to say, laws are not cast in stone. It's not the 10 Commandments. Laws are like clay to be molded. We must mold our laws to suit the circumstances of our times, and we are in dangerous times. The right to bail is not absolute. The Constitution allows us to define circumstances and to designate reasons where a person ought not to be granted bail. I do not regard this legislation as arbitrary or oppressive. If we are to claw back peace, order, and good security for our citizens, sometimes draconian measures are necessary. I thank you.
Senator Simonette.
Vice President, thank you very much for the opportunity to make a contribution to this very important clarification bill that seeks to simplify the regime for denying bail in certain circumstances. May I start by congratulating the Attorney General and Senator Vieira for very clear contributions touching and concerning the reality of our circumstances in Trinidad and Tobago. It is important for the listening public to understand the true context of this issue of bail and the denial of bail. Simply what this bill is purporting to do and aims to do is to amend an existing piece of legislation, which is the Bail Act, Chapter 460. The Bail Act itself stipulates, as it exists today, circumstances in which bail ought not to be granted, and a regime that addresses that issue. So this is not, as it were, an entirely new issue or some elephant of denial that comes to those of us vested with the duty to implement good laws and laws in the protection of the general citizenry. So that words in description of the amending bill, such as arbitrary, capricious, draconian, dictatorship, etc., are quite frankly, Mr. Vice President, irresponsible and simply to be rejected. What in essence is the effect of bail? Bail is not an order setting the accused free. Let us be clear about that. So when we talk about an infringement of a constitutional right, that is not a right, Mr. Vice President, that bail creates and that accordingly is being infringed by this amendment. And that is elementary to all constitutional and criminal lawyers amongst us and in the general society. Bail, in effect, is a procedure and a structure that aims to release an accused from the custody of the police and to entrust him or her to sureties. Sureties meaning those who stand in guarantee to the court that the accused will surrender to his trial and hearing. And those sureties, as we know, are entitled to seize the accused to ensure that that compliance is effected and achieved. So, Mr. Vice President, the effect of bail is not to entitle an accused to some absolute right to liberty, but in appropriate circumstances to liberty pending trial. The Parent Act recognized that for certain serious offenses and on certain conditions that the Attorney General shared were convoluted, unworkable, and therefore themselves capricious, the accused is not entitled for those serious offenses to a grant of an order of bail. The intervention, therefore, in clarification of the law, Mr. Vice President, is welcomed and as demonstrated by the statistics in the area where curtailment of bail was instituted for kidnapping in years gone by, with a very high likelihood of reducing criminality in the specific areas. In terms of the right to bail, Mr. Vice President, again, one needs to understand whether or not there is an automatic grant of bail. I think that it is generally accepted to be correct that you have a right to apply for bail, and that save and accept in certain circumstances wherein the court exercises its deliberation and discretion to not grant bail, then such applications for bail for non-serious offenses will proceed. Again, with that regime for the deliberations and considerations and circumstances in which bail may be denied, having existed not just at common law, but within the Parent Act at Section 6, it is important to appreciate that these circumstances that the court is entitled to consider in its discretion rebut any suggestion as being contended for by the Shadow Attorney General as being capricious or denial of some absolute right. So let us be clear. Where you have a right or an entitlement to apply for bail, and where the court is vested with a discretion, the considerations that the court is entitled to take into consideration certain matters in exercising its discretion not to grant bail. That exists today, and that exists clearly under Section 6 of the Parent Act. And the more important sections or more important considerations are as follows. Where the court is satisfied that there are substantial grounds for believing that the defendant, if released on bail, would, 1, fail to surrender to custody, 2, commit an offense while on bail, or 3, interfere with witnesses or otherwise obstruct the course of justice, whether in relation to himself or any other person. Those I would call the principal considerations. So that coming to the bill, Mr. Vice President, what is the bill seeking to do? The bill seeks to amend the Principal Act and to indicate that for a certain period of time and in certain circumstances, there shall be no grant of bail to a category of accused. Before going into the particular sections, Mr. Vice President, in a nutshell, what are we seeking to do as a government with the amendments proposed in this bill? We are seeking to address, firstly, and to define with clarity, cleaning up of what in the parent bill is the second, I believe, schedule. And that addresses the serious offenses that we are seeking to treat with. In the first instance, we are seeking to treat with firearm offenses. And we can accept, Mr. Vice President, that regrettably in Trinidad and Tobago today, we can speak of a gun culture. And quite frankly, Mr. Vice President, we would be negligent in our duty as legislators, and dare I say, recklessly so, if we cannot, with commonsensical appreciation, focus on treating with what is now, as I said, the gun culture of our society. So that the main thrust of the priority focus in order of priority is the gun culture, firearm offenses, and those who attempt such offenses with the use of firearms. The other category of offenses being treated with in a very clear and precise manner are serious offenses against women and children, and that is sexual offenses. And we can all appreciate what this Parliament has been doing and this Attorney General and government has been doing in attempting to amend and modernize the Sexual Offences Act in addressing the question of pedophilia and the registration process for same. In relation to the other issue that we are required to consider in relation to the denial of bail at first application, as it were, is what is the balance proposed in the legislation, in the bill, to bring proportionality to the process. And that balance, Madam President, is contained at proposed Section 5, amendment to Section 5 at Section 5(4). Where the proportionality is set out in permitting there to be an application to a judge in circumstances where no evidence has been taken with regard to the particular charge within 120 days of the charge. So that if there is a delay in ventilating the innocence of the accused, that delay is capped at 120 days, permitting for there to be an application by that accused for bail to a judge. In my respectful view, Madam President, that provision achieves proportionality, whereas with otherwise there would be no, as it were, consideration of delay as it affects the liberty of the citizen or the person, and more so a person who may well be innocent of the charge laid. At the same time, the proportionality exists that if you participate in serious crime, and in the light of this legislative amendment, you are now made fully aware that the consequence is that you will not be eligible for bail immediately, eligible to apply for bail immediately. Again, in relation to proportionality, we see that the liability of parents and persons in loco parentis who may be liable to a denial under the Anti-Gang Act are permitted to approach the court if evidence has not been taken within a period of 60 days, a reduced period of time for, if I may put it this way, alleged bad parenting. Again, Madam President, in my respectful view, that is a proportionate approach to persons who may well be in a position to marshal qualitative arguments as to why they ought not, after a period of 60 days, to remain incarcerated. What does the legislation address in terms of its modernization? Well, at subsection 6 of section 5, we treat with the question of deportees and/or those criminal elements who wish to practice their criminality cross-border. So that is, if you are a person arrested and you are a deportee or who is charged in another jurisdiction, then you are caught by the provisions of this bill, provisions of the proposed amendment to the Act. Again, in my view, that is bringing our legislative intervention to address the realities of our society and our environment in today's situations. Of course, the exception to the 120-day rule are offenses under the Firearms Act. And again, that offense under the Firearms Act, or rather offenses under the Firearms Act, are carefully now by subsection 8 of section 5, treating with a definition of ammunition that brings the law into the modern day circumstances. Ammunition, of course, being described to capture all categories of explosive, projectile, detonators, and the like, used for causing explosions and used in criminal ammunition assisted and aided type circumstances. And so the Attorney General and this government cannot be faulted, Madam President, for addressing amendments of this nature that seek to update the existing law. Just hearkening back to the categories of offenses that are addressed by the proposed amendment to proposed amendment to section to section 5. These are now set out in the amendment and in the new schedule part 2 of specified offenses. In summary, Madam President, we can appreciate that the focus is on serious offenses. What is the distinction, serious offense to other offenses in these circumstances and in the circumstances of the wanton crime in our country? Criminal offenses could comprise serious offenses, but that are not relative to harm to the person, death, destruction, mayhem. So, for example, offenses that are ordinarily described as white-collar crime, offenses that are not serious, which are obviously the summary offenses, etc. These are not affected or addressed in this schedule. What offenses and categories are therefore addressed? Offenses under the Anti-Gang Act, and we know that side by side with the gun culture we are now experiencing in Trinidad and Tobago, wanton gang culture, gang-related organized and mobilized criminal activity. Offenses against the person punishable by imprisonment for a period of more than 10 years, and those under sections 48 and 54 of the Offenses Against the Person Act. Dangerous drugs, along with the gun culture, as Senator Vieira quite correctly indicated, you have the drug culture, and that is the illegal drugs and narcotics, sale, use, profiting, and the related criminal activity, much of it aided and abetted by the use of guns and ammunition. Kidnapping has always been regarded and was itself addressed by a former UNC government, is included in the schedule. Sexual offenses where the alleged victim is a child, including sexual offenses under the Sexual Offences Act or the Children's Act. And again, statistics have been ventilated in this honorable chamber, Madam President, indicating hundreds of sexual offenses against children. And I believe that Honorable Senator Thompson, he has tried to alert the society and alert this House as to the seriousness of the prevalence of offenses against, sexual offenses against children. Of course, we have had correlated activity, legislative activity, to address this issue and to address ameliorating the continued increase in offenses against our children. Again, serious offenses, sexual offenses punishable by imprisonment for a period of 10 years or more. And of course, these would address rape and the like. Anti-Terrorism Act offenses punishable by imprisonment of a term of 10 years or more. Human trafficking, again, a modern activity affecting both women and children. And this is dealt with here. And of course, firearms offenses and criminal activity involving firearms and ammunition. The schedule also addresses charges which seek to, which establish attempts at the above offenses. So what, Madam President, is a legitimate cause for the out-and-out rejection of this bill by the opposition? We have heard from the opening batsman for the opposition, the Shadow Attorney General, that the bill will be rejected on the basis that it is a denial of the constitutional rights of the citizen, that the bill is in some way arbitrary, irrelevant, a suppression of constitutional rights, and that this is established by its requirement to be passed by a special majority. He relies also on the fact, not by reference to the statistics, but by reference to an alleged position taken by an earlier opposition that on some one or other grounds opposed similar amendments. With respect, Madam President, our duty here today is not to harken back to invent arguments as to why, via some previous position taken, one should reject a sensible and proportionate intervention aimed at bringing a reduction in the likelihood of those who offend while on bail, or additionally, those who are repeat offenders charged with similar serious offenses who are denied bail or denied the right to apply for bail. It cannot be that we embark on our legislative function merely in some quasi-academic exercise to score points against each other. I think it is instructive, the approach taken by my learned and long friend, Senator Vieira, in addressing the fundamental objectives of the bill by reference to the realities in our society today. And what is the logic in attempting to paint some unconstitutionality when the Parent Act itself recognized the requirement for a 3/5 majority and was passed? Are we here tinkering with any fundamental right? Answer, no, we are not. What we are seeking to do is to address and tweak what existed in the Parent Act, to expand it and to provide a proportionate balance within which it ought to operate. So that where does the departure from constitutional adherence and our duty as legislators to uphold the Constitution exist, where the Parent Act obtained the 3/5 majority? In compliance with what we do when we embark on legislation of this type, this bill likewise requires a 3/5 majority. But it is not a new bill. It is not a new item of legislation addressing for the first time the matters that it addresses concerning the issues of bail. So let us be clear, Madam President. Arguments that seek to paint this government and the Attorney General as in some way recklessly or flagrantly or capriciously departing from a respect for the Constitution, embarking upon some violation of the Constitution, are quite frankly unavailable to the opposition on this occasion, indeed on any occasion. But in particular, with regard to the serious work and the serious matters that we are embarked upon under this amendment bill. Let us be clear about that. And it is for that kind of reasoning or lack of reasoning that the playbook adhered to by the opposition will be rejected by the general population. So I urge my learned friends on the opposition bench, reflect. Reflect. And, well, you could proceed to reject, and you will be rejected. That is guaranteed. So continue. 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 Ignore the kind of sobriety of the independent bench at your peril.
Please, members, please continue, Senator Simonette.
Thank you, Madam President. I know that my learned friend will indeed reflect over the lunch period, but so be it. Madam President, the constitutional infringement arguments and the care to observe any likelihood of infringement are matters to be taken into consideration without doubt. We look forward, Madam President, to the proposed amendment indicated by Senator Vieira. But let me respectfully make clear that I do not consider that there is any fundamental attack on the constitutional right of the citizen contained in this bill. This bill is not denying bail to those who are entitled to apply for bail for offenses and charges and the like that are not contained in Part 2 of the schedule. This bill is addressing a clarification of the circumstances in which the Parent Act already sets a framework for offenses for which bail is denied. It clarifies what I can only adopt in terms of adopting the Attorney General's description, the 3-strike, 2-strike, 1-strike rule, so that it brings a definitive degree of certainty to the operation of the law, wherein we are treating with the question of reoffenders or similar crime offenders who are applying for bail. Madam President, in relation to the offenses that are, or rather the amendment to Part 2, which is the schedule of serious offenses, of course, what is now done in a comprehensive manner is the setting out of the relevant correlated items of legislation, all of which address serious criminal offenses, serious criminal activity, and the attendant likely harm to the population and the citizenry.
Senator Simonette, you have 5 more minutes.
Much obliged, Madam President. The likely harm to the population and the citizenry occasioned by those who are resolved to engage in such criminal activity. Madam President, as legislators, we are obliged to act. We have a duty and responsibility in this place and in the other to put the concerns of the citizen first and ahead of any partisan interest, agenda, or ambition. Madam President, I believe that this bill intervenes as part of a suite of intervention in the administration of criminal justice that this government and Attorney General has embarked on and that will undoubtedly bring results when it is passed. In closing, Madam President, I urge my friends on the opposition bench to be sensible and to reflect sensibly. I welcome the support of the independent bench, and I thank you, Madam President.
Honourable Senators, at this juncture, we will suspend the sitting and return at 2 p.m. When we do, Senator Mean will begin her contribution.